If you were falsely accused of domestic violence, you may have some ideas of some actions that you would like to take. You're probably feeling really frustrated, really angry, maybe really sad, and you want to do whatever you can to help your case. But in this video, I'm going to be going through 5 big mistakes that people who are falsely accused of domestic violence make that can actually really hurt their cases. And this applies to anybody. It doesn't matter how smart you are. It takes experience to figure out what is actually helpful and what can really hurt you when it comes to the criminal justice system. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. Now, a lot of people who are falsely accused of domestic violence are also facing restraining orders. If you are, I also have a course called Defeat the DVRO, in which, after watching people screw up their hearings time and time again while waiting for my client's case to be called, I made this course to teach you everything that you need to know to win your hearing. So if that is something you're going through, if that's something that you're interested in, you can find your free first class in the course via the link down below. Okay, so let's jump right in. Let's talk about the 5 big mistakes that criminal defendants who've been falsely accused of domestic violence really hurt their cases. Number 1, failing to properly manage your relationship with the alleged victim. If the two of you are still together, the last thing that you want to do is break up with the other person. Even if they falsely accused you, even if you were already breaking up when this happened, which is very common. You try to break up with somebody, they freak out, they call the cops, they accuse you of domestic violence. Now you are kind of stuck with them. From a moral standpoint, from a human standpoint, it really doesn't seem right that you would be stuck with them, and it's not. But if you break up with them, it's going to make your domestic violence case potentially much worse, because it's not up to the alleged victim whether charges are filed. But if they're on your side, that certainly helps. And if they are against you, if they are pissed off, if they're contacting the DA and saying things like, this isn't the first time that you've been violent on other occasions, maybe falsely saying that you contacted them in violation of a protective order even though you didn't, coming up with all these new allegations, that is almost certainly going to make your case worse. So unfortunately, even if you want to break up with them, that is the last thing that you should be doing. Of course, some relationships are so volatile that maybe it would be best for you to do that. You have to make your own decision, but if it were me, I'm not breaking up with that person. If things get out of control, I'm just going to walk away, take a walk around the block, and just try to keep things as calm as possible. Number 2, try to get the other party arrested or try to get charges brought against the other party. This is really common. If you were falsely arrested for domestic violence and you're thinking, hey, I'm the victim here, this is BS. Not only should they drop the charges against me, but hey, I had injuries and they should bring charges against them. People who think this will sometimes go to a police station and try to make a report. After you get arrested for domestic violence, before your first court date, you'll get a call from a detective. You probably won't know who it is. My advice is don't answer any calls from unknown numbers. Let them leave a voicemail. And if it's a detective, don't call them back. Hire an attorney to call them back, or if you can't afford an attorney, then just nobody calls them back. But a really bad idea that is actually pretty common is to pick up the phone or call the detective back and try to explain the situation to them and get them to file charges against the other person. Once you've been arrested and you had to bond out of jail, the detective's job is not to detect. Whatever detection the police department was planning, they already did when they decided to arrest you. That's kind of it for them. So when the detective is calling you, they're hoping to get a statement from you that is incriminating. That's their goal. They're not going to suddenly file charges against the other party because you suggested it to them. It doesn't matter how reasonable they seem. Their job is literally to manipulate you, to get you to talk to them, to say things that you wouldn't otherwise say. And what can happen now is that maybe this was a case that wouldn't have been filed, because when you bond out of jail before your first court date, the prosecution, not the police, lawyers have to look at this case, look at the police report and anything else that is in the file, and decide whether or not to file charges against you. And typically, as an attorney, I always tell people it's best to have an attorney intervene before the first court date and try to get them to drop the charges. And part of what we're trying to do there is we are giving them all the good things about you. Character letters. Maybe the victim is on your side and we want to give a statement from the victim. We want to make sure that that all makes it into the file. What I don't want is to have statements from my client who at that point will not have seen the police report most likely, potentially incriminating statements to bolster their case against my client. And you may think, well, I wasn't going to say anything incriminating. But what if you accidentally say something inconsistent? They're going to use that against you. It was an accident, but now in their eyes you're a liar. And now they're more likely to file that case against you. But again, what are they not going to do? They're not going to file charges against the alleged victim. And even if they did, there's still a case against you. You're on the defensive here. As a criminal defendant, and I know it is hard to, it's so unjust, right? Especially if you did nothing wrong, if you're falsely accused. It's hard to take, it's hard to accept, but you are just defending. That's all you can do. Even if you win a jury trial, you don't get anything. They don't then lock up the other party. All you get is the case is closed. So from the very beginning, your goal should be get this case closed, get it dismissed, get rid of it. That's what you want to do. You don't want to add more things to it. Number 3, post about the alleged victim or the case on social media, even if you don't mention them specifically. Now, I know that this doesn't apply to everyone. A lot of people like to keep everything private and don't want to post on social media. But for those that do post on social media, it's going to be a temptation. People who post their daily lives, I mean, this is something very significant. And maybe you're thinking, okay, but of course I'm not going to mention the other party. I'm just going to post about injustice or lying alleged victims, or don't post anything like that at all, because it's not going to help your case. For sure, it's not going to help your case, and it could potentially hurt your case. Maybe nothing will happen, but maybe it could really hurt you. In restraining orders, people love doing this. I've had multiple clients during the initial consultation where I actually go through their TikTok and I'm like, what? Delete all of this. And somebody could have screenshotted it before then, and they're basically just creating evidence against themselves. If you're posting something where you're looking cocky, getting out of jail and looking really cool and there's rap music going, I mean, I don't know. I'm trying with the TikTok, but I'm not that cool. But let's say that you post that and the alleged victim shows it to the DA. That may make the difference between the DA deciding that you are a jerk who's not taking this seriously and filing against you, or maybe offering you jail time when you wouldn't have gotten jail time without that. And it's really not worth it. If you want to post on social media, then at least wait until the case is over and then go ahead and post. Number 4, if there is a restraining order or protective order of any kind, try to contact the alleged victim, even anonymously. Okay, so there are a few different types of protective orders that might be in place. One is that when the cops come out and they make their arrest, they will ask the alleged victim, do you want an emergency protective order? That emergency protective order typically goes for 10 days. It will say on it what date it expires. So that's the first type. The second type is if the other party goes into court themselves and files a temporary restraining order, which then has a hearing and can turn into a restraining order that goes for up to 5 years. So this is where you will get documents that are usually handwritten by them, or if they have an attorney, then it'll be typed up, that explain these allegations of abuse and say that you have to stay away from them, stay away from your home, stay away from your workplace, whatever. Many times these will come up when children are involved or when you lived together. Maybe the alleged victim didn't even know about doing this, but the cops will sometimes give them legal advice and tell them, oh, you should go get a restraining order. They go down to the courthouse. It's super easy for them to get one there and get free legal help. So they do it. And then for the temporary restraining order, those are granted in most cases. The judge just has a big stack of them, looks through them real quick, makes sure that there is at least some sort of allegation of abuse, and then basically rubber stamps them. So those are super easy to get. But about 21 days later, there will be a hearing in which the alleged victim has to actually present evidence and prove by more than 50% to the judge that it's necessary to have a longer restraining order for up to 5 years in order to prevent the occurrence of future domestic violence. And those hearings are supposed to happen within about 21 days, of the initial temporary restraining order. Many times, especially lately, the courts are super clogged and they will push the hearing out a little bit, which does give you a little bit more time to prepare. But if you are unable to see your kids or unable to go home, then that's a big problem. So you can fight those, and you can fight those on your own. You just have to know what to do. And that is what the course Defeat the DVRO is all about. And sorry to plug that again, but it is really important. It does teach you how to fight those. That is the only type of restraining order that I'm mentioning here that you can actually fight. The other one is a criminal protective order. So a criminal protective order happens at the first court date in a domestic violence case if they have filed charges against you. What happens is that the prosecutor will tell the judge about the allegations in the case from the police report, and then the judge will issue a protective order. Now, if the alleged victim is there, so if you are still together, the alleged victim can say to the judge that they are not afraid, that they don't want a restraining order, and this is the one that sounds really counterintuitive, but trust me here, if you're in California. The third one is that if anything were to happen, they would call 911. So they can explain that to the judge and potentially get the restraining order either dropped down to level 1, which means peaceful contact is okay, you can do everything you would normally do, you can live together, talk, see each other, everything, or potentially not issue the criminal protective order at all. Okay, so what I have seen, even really, really smart criminal defendants do is when there is one of these in place, one of these protective orders in place, what they will do is they will try to contact the alleged victim, because usually this is somebody that you knew really well. Maybe you were in love with, maybe they were in love with you. You guys knew each other for a long time. You shared all of your deepest secrets. You were best friends. And you're thinking, okay, if I can only talk to them, they don't want this for me. Like, they don't want me to go through all this. Maybe I miss them and I want to contact them. So what some people will do is send them, an Instagram message from an anonymous account, use WhatsApp or one of these numbers spoofing things to send them a message, call them on the phone thinking, well, they can't take a screenshot of this, and I won't say who I am in case they're recording it from a number that they don't know. All of this is a bad idea. Because if they decide that they are suddenly on your side and they don't turn any of this over and they never use it against you, then sure, maybe you get them back on your side. Maybe. But if that doesn't work, and look, this is someone who, if they haven't reached out to you and they're not saying, hey, I miss you, I want to drop all of this all together, and if this is not someone that you can really trust, and you probably can't if they caused all of this to happen to you in the first place, right? So if they tell the prosecutor about this, and it doesn't matter if they don't have any solid proof, it doesn't matter at all. If they tell the prosecutor about this, what the prosecutor can do is at your next court date or at your first court date, what they can do is ask for your bail to be raised. So let's say that you paid $50,000 bail, you had to pay $5,000 of that, but your bail was set at $50K. You show up at your first court date. First of all, it's more likely that charges are going to be filed if this happens before your first court date. But you show up there, and now the prosecutor has filed an additional charge, and they ask for your bail to be an additional $50K. If you don't have an additional $5,000, if you can't get your bail bondsman there to post the additional $50,000, you will go into jail. And let's say it's your third court date or your fourth, and this happens. And maybe you contacted the alleged victim early on in the case. But now, here we are, a few court dates later, and the alleged victim decided, you know what, I don't like him anymore. I saw him post an Instagram post with a new girl. I'm mad, so I'm going to tell the prosecutor about the time that he contacted me. Well, now the prosecutor is going to be able to, again, file a new charge against you, and now your bail is going to be increased. So you might show up at that court date thinking it's going to be like all the rest. Maybe not a whole lot is going to happen. Your attorney will negotiate with the DA, will present some evidence, try to get the case reduced, dismissed, whatever, but instead, you end up going into jail. By violating one of these protective orders, you're giving them something that they can hold over your head for the entire case. Number 5. File a restraining order against them. This is a terrible idea, even if they filed a restraining order against you. Filing a restraining order against someone is going on the offensive. It is causing them to feel a really, really strong rejection. If you've been served with a temporary restraining order, then you know what I'm talking about. This feeling that now, first of all, your relationship is sort of aired in public. There usually going to be lies or at least exaggerations in the paperwork. And now you have somebody that you loved or you were close to or you hooked up with who's literally asking the government and some anonymous judge for intervention to keep you away from them. Now, a lot of people think, and even really smart clients have told me that they want to file a restraining order against the other person. Their feeling is that in the criminal court, it will make it seem more like they are the victim. That if they were just acting in self-defense, they were actually the abused party. It will somehow show that to the court. Like, look, I even had to file a restraining order against this person. Don't do it. Because what happens is, again, the other person now is even more upset. And sometimes actually the prosecutors get upset about this, and they consider this almost a form of harassment. You know, I actually had someone contact me recently whose probation officer was demanding that he drop the restraining order that he had filed against the other person. Otherwise, they were going to say that he had violated his probation. That is basically how the criminal justice system views these. And if you're thinking, yeah, but they filed one against me, I need to file one against them too, so that the judge sees that we both have one against each other, and that it's not that I'm more culpable, they are. All right, if you think that, you better go right now and take the free first class and defeatthedvro.com. I'm not kidding, because this stuff is not intuitive, and that is not how it works. I mean, there are some lazy judges that will just grant restraining orders against both people, but the problem there is that this actually can show up on background checks, and it can hurt you for employment. It can hurt you for housing, professional licensing. I mean, it can really be a problem for you to have this on your record, a restraining order. But a lot of judges will see it as you retaliating, and will see it again as, even though it's your right to file it, they'll see it as almost a form of abuse. Like, you didn't file this because you were actually afraid. You filed this because they filed one against you. Maybe you're thinking, but they haven't filed one against me yet. Maybe I can beat them to the punch. That probably is not going to do anything if you were already arrested. It's not going to have a good result for you. Again, remember, if you were arrested for a criminal case, for a domestic violence case, what you want is to get rid of it, not to add more things to it. You want to get rid of it. You want to just quash it. You want to get it dismissed. You don't want to add more complications to it and problems to it. You don't want to add more things that make the alleged victim more and more upset, or make the prosecutor look at this and think, you know, this guy is really a piece of work. He's filing this restraining order against her. He got her kicked out of her house even though he had been arrested. I mean, this is really not right. And by the way, I said her house, but this applies even if it's your house and paying the rent. Got her kicked out of her home. That is how they view these things. And so you want to make sure that you avoid doing that. I hope that you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation via the link there. If you have a domestic violence restraining order, again, please go at least get your free first class. I talk about things that I don't talk about on YouTube, that actually I don't think anybody talks about on YouTube, even in the free first class. And if you did find this video helpful, please don't forget to like, subscribe, and ring the bell.